tables bending, broken rules. Hound dog howling, bullfrog croaking. Everything is broken.
Hello and welcome to another edition of Dad's Divorce. Today we have with us Kristen Zirk, an attorney with Cordell & Cordell. And Kristen was with us a few episodes ago, and today we're going to talk about vocational experts, which are used in the majority of dissolution cases, legal separation cases, and also in motions to modify. Kristen, welcome. Appreciate you taking time out of your schedule to be with us.
Thank you, Dan. Thank you for having me.
And as I mentioned, we're going to talk about vocational experts, and if you could just kind of give a brief description on what exactly is a vocational expert.
Sure, Dan. A vocational expert is someone that you're going to hire to help you in your case to build up the case against the opposing party if they are underemployed or should be employed at a different area in which they're currently working. So, for example, if you have a stay-at-home mom who has a master's degree and she's been home for 5 years and the kids are about to go to school, you're going to want to hire a vocational expert to let the judge know that even though she doesn't have a job right now, she very well could have a job and be earning a certain amount.
Sure. Now, there's a battery of tests that vocational experts perform on an individual once you retain them. Can you go what the first step would be once you have the actual vocational expert retained? What is the initial appointment like?
Sure. The first thing, after you retain a vocational expert, the first thing the vocational expert is going to want to see is a copy of that opposing party's resume. So they're going to want to see what the past job history has been. They're going to want to see how long it's been since they've been working and what their salary history has been. At some point, the vocational expert is going to want to meet with the opposing party and talk to them and try to get a better feel, and even, as you suggested, might run some occupational tests with them to help get a better idea as to where they are or they could be in their career. But sometimes, given cases are sometimes nasty and there's not a lot of cooperation on the other side, there's a very good chance that your vocational expert might not be able to meet with that opposing party.
Sure. Now, getting a vocational expert involved is important to be able to impute income to your spouse. Now, why is that important to be able to impute income to the spouse?
Well, it's usually important in two folds. Fold number one could be on a maintenance case or an alimony case where they are saying that they can't meet their own reasonable needs. But if they have an education and a degree that they're not using, well, there's a way that they could be meeting their own needs, they're just choosing not to. The other realm in which it could be useful and helpful for is in child support, if calculations for a state's child support are as a result of gross income.
And what you're saying is on that change, it's going to reduce the potential amount that you are exposed to paying for child support if we can impute income to mom.
You are absolutely right, Dan. It will seriously reduce your exposure both on maintenance or alimony or on child support.
What exactly is maintenance or alimony?
Maintenance or alimony is typically when a judge decides or believes that an opposing party cannot meet her own reasonable needs without having some help from the other spouse. And I say her reasonable needs because oftentimes it's men that are the ones that are forced to pay maintenance or alimony instead of women. So that the judge has to look to whether she has the ability to meet her own needs and whether or not she's actually doing so. So, my best piece of advice to my clients when they have a stay-at-home mom, and if it's a divorce, I say do what you can to try to get her back to work before you file because it's only going to help your case.
Now, the vocational expert will come into play if the opposing party is seeking maintenance or alimony.
Yes.
And how soon do you advise your clients that you want to get a vocational expert on board?
If it's clear that maintenance or alimony is going to be a part of the case, I try to do it up front because I want them to get their expert retained, get the case moving, and get them to be a part of the entire litigation because this is our linchpin. Without having the vocational expert with us in court, I'm not going to carry any weight with the judge as to whether or not this lady can be working or how much she could be making.
Now, you mentioned earlier that once you know that the other party is going to be seeking alimony or maintenance, how do you know or what determines whether or not the opposing party is going to seek alimony or maintenance?
It's typically my experience as a lawyer when people are pleading, they plead for everything up front. But where you have a case where there's a party that hasn't worked in a considerable period of time, or that the husband is the higher wage earner and a significantly higher wage earner than mom, you can almost bet she's going to ask for some maintenance or alimony.
And then will that be identified, when you say pleading, is that the petition or the complaint asking the court to dissolve the marriage?
Yeah, you'll know up front whether or not she's asking for maintenance or alimony. It should be in the papers that you are served with if you're the respondent, or that you get via your attorney if you're the petitioner and she's filed any sort of a cross motion.
So once you get the pleadings and it's determined that the other side is going to be asking for maintenance or alimony, your next step would be to contact someone to come on board as a vocational expert.
Absolutely, and then I also tell my client to make sure he can go through the computer in the house and print out a last copy of a resume. Or I put my client in contact with a vocational expert to give the vocational expert as much of a job history of wife as he possibly can if he can't find a copy of a resume on the computer. So if you have any sort of work records that are lying around the house, if she left her previous job and took a copy of her employee file, grab it for your attorney. Your attorney is probably going to want to see your tax records anyway, and those tax records are going to be passed on to a vocational expert. So at the very least, the voc can show that there's been a salary history for the last couple years of X, Y, and Z. So if you can do a little bit of that investigative work, it'll help your vocational expert move along with his or her duties.
Right. Now, once you have the vocational expert on board and that person meets with the spouse, what happens next?
After the vocational person meets with the spouse, or even if they don't meet with the spouse, what you'll then want to do is you'll want to take the opposing party's deposition early, ask as many questions as the vocational expert might want to have asked if he or she had met with that spouse, and then you give the voc all the paperwork, and then what they'll do is they'll prepare a report, and they will give the court some idea as to what jobs are out there, what she's qualified for, and what her potential earnings could be. And that's the key point. You want the potential earnings to be reported to the court so that way you can impute her at some level of income.
Right. Now, is it more advantageous, in your opinion, to take the deposition of the opposing party first or wait till the vocational expert has an opportunity to meet with that person?
It all depends on whether or not you can actually procedurally get the opposing party in front of vocational experts. Sometimes it just can't happen. You know, the judge rules against it, or just time-wise it doesn't work out. If it doesn't work out, then I'll take the deposition earlier. You know, I usually like to take my depositions right before trial, but if I have to help my voc expert, I'll take it earlier if need be.
Now, we've talked about you'll know if the other party is seeking maintenance or alimony based upon what is in their actual pleadings, which is usually a complaint or a petition for dissolution of marriage, which is asking the court to dissolve that marriage. Right. Now, what is the step to actually get the vocational expert on board? Because I'm sure they just don't all suddenly appear. What do we need to do in order to get someone on board?
Talk to your attorney that you have and see if there's anybody in the legal community that they've used in the past to help you out. Your attorney should give you some names with some recommendations of someone to retain. The attorney will then call that vocational expert, ask for a retention letter. You'll have to pay them some money up front for them to start to do their work, but it's a very good investment.
Now, once we have that expert on board, do they have to come to trial and testify?
No, there's a very good chance once you get your expert involved and they start to let you know exactly how much you could be earning, you could very well settle the case. I mean, litigation either goes to trial or it settles. So there's a very good chance you wouldn't have to pay a retainer for this guy to go to trial and testify on your behalf. But, sometimes it happens.
Well, unfortunately, we're out of time. But you can watch the entirety of this interview between Kristen Zerk and myself on our podcast, which you can go to DadsDivorce.com, click on the icon podcast, and you'll be able to download it and listen to the entire interview. Otherwise, if you're just tuning in at DadsDivorce.com, this is going to be cut short for 10 minutes. But again, if you want to listen to the interview in its entirety, you can click on the podcast at DadsDivorce.com. Also, on the website, you can click on Ask a Lawyer, and you can submit questions that we will do our best to answer on any upcoming and future episodes. Again, that's DadsDivorce.com, Ask a Lawyer. My name is Dan Cuneo, your host, and thank you for your time.